Hey guys, welcome to this video. My name is John Watts and we'll cover another case decision. This involves the FDCPA, the Fair Debt Collection Practices Act, and it also involves a collection law firm, Scott and Associates, which they are in Montgomery, Alabama. I think they're headquartered in Texas, but they're in Montgomery and they file a lot of lawsuits in Alabama. And so this was brought individually and as a class action against them. And the reason I want us to look at this is because it teaches us about pleading a lawsuit. In other words, how do you draft a lawsuit? How do you write the lawsuit? And also about a cease and desist type letter, because there's still a lot of confusion about that. And I think the judge does a good job of laying out what happens here. So let's jump into this case, and you can see this just came out a very short time ago. So there's a motion to dismiss, and this is brought under Rule 12b-6, and basically what that says is, look, there's no way the plaintiff can win, even if you accept everything that they say in their complaint as being true. They still lose. And so what are we talking about here? Well, we've got this lawsuit against Scott and Associates against saying they violated the Fair Debt Collection Practices Act. And this is a critical issue. The plaintiff says, hey, I notified either the creditor, Barclays Bank, or I notified the collector, which is this law firm, Scott and Associates, in writing, which you have to do if you're doing a cease and desist letter. And they say, but after we sent that cease and desist letter, we got another letter from Scott and Associates, so that's why we're suing. Now, the court doesn't copy the letter, but we can see later on exactly what was in that letter. And so there's a couple of counts or claims here that are made. So we've got count 1 is it violates 15 U.S.C. 1692C, which prohibits a debt collector from communicating with a debtor or a consumer after receiving a cease and desist letter. And then the next part of it says you violate 1692E, which says to a debt collector, you cannot do anything that's false, deceptive, misleading, just none of that, no trickery here. And so we've got the law firm files a motion to dismiss and said, well, you never claimed who you sent it to. Did you send it to Barclays, the creditor, or did you send it to the collection law firm? And the plaintiff, as plaintiff has a right to do when faced with an initial motion to dismiss, amended the complaint. And the court says, but again, she failed to allege who she sent the letter to. And so then the motion to dismiss was renewed, or the law firm asked again that the judge dismiss the case. And so let's look at what we've got here. So say the plaintiff has not alleged she sent a cease and desist letter to a debt collector, and that's a necessary precondition to get the protection of 1692C. And then the law firm says, even beyond that, the letter we sent after the cease and desist letter was exactly what's allowed by the law. And the plaintiff says, well, wait a minute, I should get the inference that I sent the letter to the law firm and not the creditor. And after you, as a debt collector, after you get a cease and desist letter, you cannot communicate with me at all. And the letter was confusing. And so the court says, well, look, we're going to assume the factual allegations are true and give them the best possible light and favor the plaintiff, because it's the defendant, the law firm, the debt collector, trying to throw the case out. So we're going to give every benefit of the doubt to the plaintiff. And then the court reminds us it's got to be sufficient factual matter. It's got to be plausible. Doesn't mean it's more likely than not. It doesn't mean you'll definitely win. But it does have to be within the realm of plausibility here. In other words, the court has to look at that and say, well, I might rule against you if I was a jury, but I can see that, there's a chance you could be successful here. And so the court ends with sort of this analysis before we get into the actual heart of the case. Sufficient facts to support a reasonable inference the defendant is liable. So let's start off with count 1, which is under 1692C. And so here's the language of the law. Pretty specific language. Notifies a debt collector in writing. So it can't be somebody other than a debt collector, and it can't be anything other than in writing, that the consumer refuses to pay a debt, or the consumer wishes the debt collector to cease further communication. The debt collector shall not communicate further with the consumer with respect to such debt. And then there are some exceptions. And we've done videos over each section of the FDCPA, and you can refer back to the 1692C if you want more detail on that. And so they say, first of all, the amended complaint does not allege that the plaintiff sent a cease and desist letter to a debt collector, that is Scott and Associates. And the court says, yeah, that's right. It says it was sent to someone, but it does not identify to whom she sent the cease and desist letter. And so the plaintiff says, well, I got a letter from Scott and Associates, so either Scott and Associates got my letter, or the creditor that hired Scott and Associates got my letter. So it's got to be one or the other here. And that's a pretty good argument. And so let's look here, the first argument here. So argues that notifying either a debt collector or a creditor is enough to invoke the protections. And the court says, but here's the problem. That's not what the law actually says. So creditors are not subject to the FDCPA. And creditors and debt collectors are defined. And if you'll remember our video on 1692A, where we go over the definitions, I think I said something like, it's not the most exciting thing. It's basically a glossary, but it's really important because we have to know what these words mean to then understand later on in the statute, do I have a valid claim or not? So a debt collector is expressly defined not to include a creditor except in unusual circumstances. And so not really important or relevant here to us. It's just saying a debt collector is not a creditor is not a debt collector. And so we have here, a consumer must contact a debt collector, not a creditor, to invoke the protection of this section of the statute. And it's citing to a case from Wisconsin. And then second, the plaintiff says, well, look, there's two equally plausible inferences. Either I sent the letter to the law firm, the debt collector, or I sent it to the creditor. It could go either way. And since we're at a motion to dismiss, we're not at trial, we're not at what's called motion for summary judgment after all the discovery and depositions have been taken. But we're at the beginning stages. You should give me the benefit of the doubt. And the court notes, okay, you're right, that even when assertions in a complaint are ambiguous, they should be construed in a light most favorable to the plaintiff. But here's the caveat. You only get reasonable inferences. And the court says it would not be reasonable in this situation because this information is uniquely within your possession. In other words, plaintiff, who did you send the letter to? You should know. You wrote the letter, whether you signed it or not. I mean, you don't have to sign a letter, but let's say she signed the letter, and then you put in an envelope and you wrote an address on it. Who did you send it to? And the plaintiff doesn't respond to that other than to say, well, I must have sent it to either the creditor or the law firm because the law firm sent me this letter notifying me that they would not contact me anymore, but they might do some other stuff to me. And so let me just take a step back here. I know I harp on this a lot, but if you're going to send a letter, you got to keep a signed copy of that letter. Not just a Word document, not just a Google document, but a PDF and a physical copy of it. So if you're sending it, for example, to Scott & Associates, you print out two. You sign both of them. You send one by certified mail. And the other one you keep and you scan it in. If you don't have a scanner, just get a little free scanning app on your iPhone or Android phone, or if nothing else, take a picture of it. But have that so that there's no doubt about who you sent the letter to, when you sent the letter. And then you wouldn't have this problem. And so while the plaintiff is making good arguments here based on sort of the facts that they're operating under, which is obviously the plaintiff has no idea who she sent the letter to. So the lawyer's doing the best he can with this. But you got to keep copies of what you send. Because if you're sending it, there's a chance that will be important in the future. And you don't want to be in this situation where you're telling the judge, well, I don't know, so you should just assume I sent it to the right person. Now, the plaintiff, and maybe the plaintiff did make this argument. Well, look, we'll figure this out in discovery, okay? Because we can ask a question to Scott & Associates. Did I send this letter to you? Now, I don't know if that argument was made. It's not mentioned here by the court. Doesn't mean it wasn't made. It just means it's not mentioned here. And so the court says, well, look, this has already been raised. You failed to allege who you sent it to, and you specifically did not make that allegation. Now, again, I think what you could make as the plaintiff here is say, well, I don't remember who I did it to, but I believe it was to the debt collector, and it's really easy. If they got a copy, they'll have to turn it over to me. And if they don't have a copy, they'll turn it over. So did the debt collector come in and say, hey, we never got this letter from you. We got it from Barclays Bank, which is not good enough. Or did they say, yeah, we got this letter? And so again, I don't know what arguments were made. All I know is the judge ultimately rejects this. And you'll see in a footnote below, the judge says, normally I'd give you another chance to amend your complaint, but you didn't ask me for another chance, and it wouldn't make any difference anyway. So then we go on to the second part here. Say, well, even if you notified Scott & Associates, their letter is fine. So let's look at the law again, because a lot of people have this misunderstanding. They say, once that debt collector gets cease and desist letter, if I ever hear from them again on anything, or at least on this debt, they're in trouble. That's not the law. Again, we have to go look at the actual text. And that's why I suggest if you're interested in the FDCPA, go find our videos where each section of it we go through. We put the exact text up and we talk about it because we have to fully understand what this law is. So here's the deal. Once a consumer properly issues cease and desist notice to the debt collector, the FDCPA prohibits the debt collector from further communication with 3 exceptions. Well, what are those? Well, number 1, can notify the consumer that further collection efforts are being terminated. So they can send you another letter that says, we got your cease and desist, and we're not going to collect against you anymore. Number 2, notify the consumer that the collector or creditor may invoke specified remedies which they ordinarily invoke. Okay? Or number 3, notify the consumer that the collector or creditor intends to invoke a specified remedy. So let's think about this. Number 2 is, hey, we may continue to credit report, we may sue you, we may do this. Here's the 8 things that we may do to you. This third one is saying, look, out of all those options, here's the one that we intend on doing. Maybe it's suing you or whatever it might be. So the plaintiff says, well, look, once that cease and desist notice is sent, the collector cannot communicate further. But that's just not even close to the law here. That's not what the law says. The very section that gives us the right to send a cease and desist letter that says the debt collector can no longer communicate says, but here are 3 ways that they can continue to communicate. The judge points this out. That ignores express exceptions, and it follows the law by advising the plaintiff it is terminating further collection efforts and notifying the plaintiff that the creditor may invoke specified remedies in the future. So again, I don't have the letter in front of me, but I've seen 1,000 of these. It'll say, we are closing our file. We will not engage in any further collection activity. But understand, the creditor, remember this was Barclays Bank, the creditor may file suit against you in the future or whatever. And so that's all it says. And frankly, that's what the law allows. Plaintiff's partial reading of the statute's unavailing. Well, what about count number 2? And this is under 1692E, that prohibits a debt collector from using false, deceptive, or misleading representations or means in connection with the collection of any debt. And then we have all sorts of examples. It could be the identity, the status, the character, the amount of the debt, the effects of transferring the debt. And then you also can't threaten illegal actions like an unlawful arrest or seizing property when you have no right to seize the property. Now again, we don't have the letter in front of us, but it says it's not false, deceptive, or misleading. Instead, it tracks the language of the statute. Let's look at this again. Shortly after initial contact with the consumer, FDCPA requires the consumer provide a consumer with the identity of the creditor, the amount of the debt, statement that the debtor has 30 days to dispute the debt. This is under 1692G. Sometimes this is called the validation or the verification notice. And the court says no allegation that any of that was misrepresented. And then the next thing we have is that Scott & Associates, this collection law firm, debt collection law firm, says we're not going to do any further collection actions, but there may be some in the future. And the court says this is not contradictory. A debt collector, like a law firm, may well cease collection communications with the debtor while it explores legal remedies such as wage garnishment. Now, the only caveat I'd put there is you can't say we might do wage garnishment unless you already have a judgment against the person. In other words, just for a collector to call you up or write in a letter and say, we may do wage garnishment against you. If they don't say, assuming we sue you and assuming we win, then I would sue them for that because I absolutely believe that's deceptive. So I think the court's just kind of talking here and saying, look, you can do other options here, other remedies, even though they're not going to call you or write you anymore. And that's fine. The debtor still owes the debt, even if the debt collector must cease communications about it. And then Section 1692C expressly allows the collector to advise the consumer that further efforts to collect are being terminated, to notify the consumer that specified remedies may be invoked, or notify the consumer that specified remedies are being invoked. See the difference there? That part 2 is, here's the universe of things that we may do. We're just giving you notice of that. Number 3 is, out of that universe of things, here's the one that we're going to do. The statute does not limit which exceptions may use, nor does it limit the collector to choosing between the 3. A letter that makes accurate statements are required or allowed by the FDCPA is not false or misleading under that statute. And so it's granted, the motion to dismiss granted, dismissed with prejudice, and then it's kind of nice what the Middle District of Alabama does. They give you this little checklist in case you want to appeal. Well, here's the footnote that I referenced earlier. Court would normally allow a plaintiff in these circumstances a second final chance to amend the complaint, but the plaintiff did not ask for that. And the court says, there's no reason to allow you another amendment, because really the amendment would be, did I send the letter to Scott & Associates? And I've already talked about, just sort of off the top of my head, maybe some ideas you could use on that. Say, well, the defendant, the debt collector, knows whether I sent the letter, all different sort of stuff. But look, does any of that matter? No, because the court has gone through and said, let's assume you sent the letter to Scott & Associates. Their letter to you was fine. It perfectly follows the law. Now, again, I haven't seen that letter specifically, but just taking what the judge says here, it's just a good reminder. We need to be as precise as we can in our pleading, or if we can't be, let's give some explanation for why we can't be more precise. And the other thing to keep in mind is, and I may go through one day the Federal Rules of Civil Procedure, and because those are sort of the rules that we follow in federal court. And when you're talking about drafting a lawsuit, you are allowed to, and this is true in every state that I've ever been involved in, you're allowed to plead contradictory things, inconsistent things. So sometimes we'll plead, for example, that we'll say, we sent a dispute letter to the credit bureaus, and the credit bureaus notified the furnisher. Maybe it's a debt collector, maybe it's Bank of America, Capital One, Discover, whoever it is. And then the next sentence will say, alternatively, we sent the dispute letter to the credit bureaus, and they refused to send it or refused to notify the furnisher. Well, those are contradictory. And that's okay. We're allowed to do that because, look, we don't know. That's what we get to take depositions and ask discovery. So there's things that we may not know and we may plead in a contradictory way, and that's okay. But it wouldn't make any difference here because assuming the debt collector got the letter, the cease and desist letter, they still handled it right according to the judge. So anyway, hope that this is helpful to you. If you have questions or comments, you can put those below. Now, if it's something, it's sort of private in nature, just get with us directly. You can go to alabamaconsumer.com. There's a contact page, or just type in contact John Watts, JOHNWATTS.com, and that'll take you directly to our contact form, and you can get with me. And I will catch you guys in the next video. Okay, bye-bye.